Thanks so much. Yeah, take care.
For my client's sake, I hope that I'm a better lawyer than I am a surfer. So it's a pleasure to be here. It's a bit of a surreal experience having left Israel at the age of 13. My bar mitzvah was not here, but my best friend's was. And this is the first time I'm in this room since. I want to introduce with me is my partner, David Rosner. David heads our restructuring and bankruptcy group. The former head of the group was David Friedman. We used to be Kasowitz, Benson, Torres, and Friedman. We chopped his name off when he became ambassador, and David has taken up the reign. I'm going to talk a little bit, we're going to talk about trends in US litigation and restructuring. I'm going to talk about some antitrust stuff, and David is going to follow up with some bankruptcy work that we've been doing. David, in addition to being the head of the department, has been involved in some of the biggest cases in the country, such as Enron, WorldCom, Caesars recently, etc. So I thought I'll talk about US antitrust law pre- and post-merger for three reasons. I think there is a perfect storm coming, and for three factors. First, we have now a Republican administration again, which we believe will result in possibly less regulatory action of mergers and acquisitions. There's also, of course, Israeli companies are very interested in acquisitions and exit strategies. That's a second factor. And third, where you have a lot of acquisition activity, especially by strategics, and you have a lighter touch on the regulatory front, what you get is a lot of class actions by class action lawyers and consumers that follow any such acquisition. So just quickly summarizing the law, the framework, the main provision for mergers under US antitrust law is the Sherman Act, which bans any contract combination in restraint of trade. And it divides into two categories, per se and rule of reason. Per se are obviously anti-competitive actions such as price fixing, and in acquisition and mergers, it's usually plaintiffs try and argue that it's some kind of a market allocation taking place where you have competitors entering into a transaction together. Then they say it's a per se violation of the Sherman Act, and therefore you don't need to show any anti-competitive effect. It's per se illegal. Rule of reason is everything else. The court gets to weigh the pro versus the anti-competitive effects of the mergers. The other provision that applies often is Section 2, which is the monopolization provision. It's illegal to monopolize or attempt to monopolize any part of trade or commerce. And what you're not allowed to do, you're allowed to grow a monopoly through legal means, through just getting bigger, better, more efficient, but you're not allowed to use any predatory behavior, such as any exclusionary or any illegal conduct, such as predatory below-cost pricing, boycott, that kind of activity. And again, that applies to merger activity. Section 7 of the Clayton Act is the main provision used by the government in reviewing and blocking mergers. And it forbids acquisitions where the effect of the acquisition may be to substantially lessen competition or tend to create a monopoly. And the key criteria for the government in applying Section 7 is whether the proposed merger creates, enhances, or entrenches market power of a company. Consequences of an antitrust violation are criminal or civil. It's a criminal statute, and if the government prosecutes you successfully, a violation can lead up to 10 years imprisonment and or a $100 million fine. And then consumers or competitors can bring a private civil action where damages are automatically trebled, so it's treble damages, and attorney's fees have to be paid. And what's unusual, I think, for the US system is that liability in these kind of cases is joint and several. So you could be a very small player in an alleged conspiracy, but still be liable potentially for all of the damages arising. So in the case where I defended Air New Zealand in the air cargo price fixing litigation, where El Al was involved and Lufthansa and a lot of airlines, Air New Zealand was a tiny, tiny market, but it was potentially on the hook for $7.5 billion. So that's a real powerful tool that's used by the plaintiff bar to try and force companies to settle or to, well, essentially to settle early. Going back to the government regulatory regime, there is a pre-merger notification requirement in the HSR, the Hart-Scott-Rodino Act, where if a proposed merger hits a certain size, the companies must disclose information about the transaction, the company, before the transaction can be completed, and it can apply to mergers. Once HSR filing is complete, the agencies review the applications. It's either the DOJ or the FTC, can be also state agencies involved or localities. After an initial review, the agencies can ask for further information, which is referred to as a second request, and it involves a lot of work by the company in collecting documents, answering interrogatories, meeting with the regulators, etc. And if the agencies are still not satisfied after the second request, they can take legal action in federal court to block the merger. That's sometimes resolved by consent decree, which allows the merger to proceed so long as the acquirer takes certain actions, such as divesting certain portions of the acquired company to lessen potential damage to competition. So now we have a new administration in the DOJ and the FTC, which are the agencies that review acquisitions and mergers, are executive branch agencies, and the senior staffing will be affected and determined by the president. And when you look at the patterns historically, you can see different patterns in different administrations. Stereotypically, Republican presidents have been considered more pro-business and less interventionist than Democrats. And we have some charts that show that you see a jump under President Bush as opposed to President Clinton, but that's really because they changed the limits for reporting transactions up to $50 million from, I think it was 15 before in 2001. So that's why there was an increase there in percentage of mergers challenged by the president. Under President Obama, there was a very much higher percentage of mergers that was challenged by the administration. So given Republican control of Washington now, and given the market valuation and the hot Israeli market, there is reason to expect there will be a lot of merger activity involving exits, and we have some examples there that I'm sure you are all much more familiar with than I am. And what we think is interesting is that there is a savings clause in the Clayton Act. So even if a transaction is approved by the government, and even if it's approved by the DOJ, and if it's a telecommunication deal approved by the FCC, and approved by all of the localities and the AGs, it can still lead to a private action. There is no prohibition, there's no immunity. And those are usually brought as class actions. And in recent years, that's been a real cottage industry for the plaintiff bar. The reason is that there's been a lot of restriction on securities class actions. Some of you may be familiar with them, that there's a lot of, used to be a lot of strike actions. As soon as a company share price would drop, class action lawyers would run to court, commence 10b-5 actions under the Securities Act. The Supreme Court has issued many decisions curbing that. There's also been some legislation making those actions more difficult. So entrepreneurial plaintiff lawyers have turned to antitrust, and they often come as a result of government investigations, such as the LIBOR or the Forex or the air cargo case I mentioned. And they also can follow mergers and acquisitions. And the real issue is going to be, will the treatment be per se or rule of reason? So giving you the example of a case I worked on, the Comcast case. Comcast is the largest cable company in the world, largest media company in the world, also owns NBC and Universal now. And it became the largest TV company by buying a lot of little companies, little cable systems around the country, and then swapping territories with other companies so it had big geographic clusters. Those transactions were all approved by the DOJ, the FTC, the FCC, because there was no reduction in competition because it's a franchise business. If you combine one franchise business with another franchise business, you haven't reduced competition, you just changed the name on the bill. We thought it was a pretty simple point. It was more challenging to explain to the judge, and we litigated this for many years. There were class actions brought in 3 clusters, Philadelphia, Chicago, and Boston, claiming that the clustering was a market allocation under Section 2 and a market allocation under Section 1 and a monopoly under Section 2. The case on class certification went all the way to the Supreme Court. It took a 5-4 decision that was written by Judge Scalia for us to prevail and overturn the decision below on class certification on an issue really that the damages were individual rather than class damages and therefore predominated. But along the way, there was an interesting decision for this crowd and for Israeli exits, because in summary judgment, we argued that the clustering had proper competitive benefits and was not per se illegal, and that you need to prove rule of reason. And that has led to pressure on plaintiff lawyers who then settle the case for a small fraction of the damages. So the hope is that if you do have a decision, if you do have a transaction that's approved by the regulators, then you would be able to argue that the rule of reason applies, which is a much more relaxed standard. So that's essentially my presentation on antitrust. We can have questions now. Maybe I'll turn it to David to talk about bankruptcy, and then we'll take questions on either topic at the end.
Thank you. U.S. restructuring law, background, current trends. So, as Sheron said, I'm David Rosner, and when I went to law school many years ago, what I didn't know is that if you practice restructuring law and you represent Donald Trump in a casino bankruptcy, one day you'll be the United States ambassador to Israel. And that's exactly what happened. Our former partner and my mentor, actually, for almost 30 years, David Friedman, is now living here and is the United States ambassador to Israel, which is a great pride to us and great pride to the firm. And of course, immediately what we did was take his name off the firm. So in order to explain to him that under the ethics rules, you can no longer be part of the firm, but as I said, he's here. So now, he practiced bankruptcy law, I think, for 36 years. I've done it for 28 years. I represented Donald Trump in his casino reorganizations about 15 or 17 years ago, so I guess in about 8 years, I can take David's place and become the United States ambassador to Israel, which is my goal, of course. That's why I'm here. So what is actually restructuring? It's, and why do you care about what restructuring is? Restructuring is something hopefully none of your companies is ever going to face as a company itself that goes through a restructuring. However, as you begin to face the United States, as you begin to have operations in the United States, as you sell securities in the United States, particularly debt securities, or you just have securities that are openly traded where hedge funds begin to acquire them, private equity firms begin to acquire them. Restructuring becomes very important because you are now dealing with creditors, perhaps equity holders, but certainly creditors that could be internationally based and can certainly be based in the United States. The United States has a very sophisticated bankruptcy and restructuring system, and it is used in many other jurisdictions. There's a lot of analogs. The Israeli system, of which I've become familiar with recently because I have a case here in Israel that's been going on, it seems inexorably, for 6 or 7 years, and I think it still has 6 or 7 years to go, has had Israeli restructuring aspects to it, which are quite different than the American ones, but there's an overlap between the two. There are creditors in the United States, there are private equity firms in the United States that are involved with an Israeli company, and U.S. restructuring law plays a big, big role in what the ultimate outcome is going to be. So that's why and as I said, it's always good to know a discipline that internal counsel will look to external counsel to bring in and say, okay, we want to know what the basics are of this, but we want to use external counsel who can actually know and have the expertise to the very specifics of it. That's what we provide at Kasowitz, but we work hand in hand with internal counsel as we teach them what the fundamentals are, and they see how they can deal with their creditors or equity holders, and if the company, unfortunately, itself is facing distress, how the company itself can use the U.S. laws, both internationally as well as in the United States, in order to assist itself. So the goal of restructuring ultimately is to resolve both financial, or what I would call the capital structure issues, as well as operational distress, and to provide the company itself with the ability to go on again as a going concern. Restructuring is not about liquidation. There is liquidation in Chapter 7 in the United States. Hardly ever used. Most companies don't liquidate. What the idea of bankruptcy and restructuring is in order to reorganize and fix what can be very levered balance sheets. So that can occur in court or out of court. Any bankruptcy lawyer, any restructuring person spends a lot of time in court, but we spend even more time in the boardroom and around the conference table trying to figure out how we can restructure a company outside of bankruptcy court. Out-of-court restructurings, which are very beneficial, require stakeholder consent. You've got to bring your creditors, you've got to bring your equity holders to the table. If they're successful, very cost-effective. You're spending less money on expensive U.S. lawyers, and what you're doing is you're making a business deal. In-house counsel is intricately involved not only in bringing the stakeholders to the table, but also in advising the board of directors of shifting fiduciary duties in the context of a restructuring, which is very important because the officers, the board, and the senior management will look to their in-house counsel for an understanding of, now that we're in a restructuring mode and we've got creditors at the table, what are our obligations? Where do they extend to? Who do we need to look out for? How many stakeholders can sit at the table, and how many of them do I need to interact with? That's where in-house counsel actually works with their external counsel to gain the expertise and to advise the senior management. Out-of-court restructurings are great. Just completed one 2 days ago that I think hopefully is going to sustain a very important United States company, and but they're limited typically to the balance sheet. You can't restructure operations outside of court, because in court is where you get the benefit of what the U.S. law is in terms of breaking contracts and doing things that you couldn't otherwise do absent the consent of your counterparties. The in-court restructurings are governed by the Bankruptcy Code, which has been around since Lincoln's time in the various iterations in the United States, and now it's a statute, but it's a lot of judge-made law, and you need to have a certain expertise in what the judge-made law has been over the years. In court, the benefit of in court, as opposed to an out-of-court restructuring, is when you have a holdout group, and that's always a problem when people have been purchasing your securities, particularly sophisticated players in the market that buy up securities. They look to be the holdout to demand maybe more than what their economics really should dictate they should receive. And in court, you have the ability in bankruptcy to break contracts and take the holdout. So for example, if you're able to make a deal with 2/3 of your creditors of a particular class, and the 1/3 is holding out, and you really want to get the deal done, you bring them into court, you can get an order of the court, the 2/3 can bind the 1/3. You're able to reset the balance sheet, cancel their claims, and you're binding the minority. Outside, you've got the holdout problem. You've got the stub piece. If you do an exchange offer, if you restructure a certain debt security, and you get 90% that have agreed, but 10% don't, and everybody's agreed to exchange into a security where they're getting essentially 80 cents on the dollar or 70 cents on the dollar, the 10% that hold out, they're still entitled to 100 cents on the dollar. And it makes it very difficult if you really need to get the entire class. Your debt instruments are very important, and this is where in-house counsel, plays a critical role in what rights the creditors ultimately have. When the restructuring that we just did out of court, we had provisions in which there was actually the ability to drag along the minority holdout holders outside of court. So we had the same benefit we would get inside court, we were able to get it outside court because a certain number, a majority of holders, in this case it was in a term loan, were able to bind the minority. So we were able to get the real benefit of it. In court, as I said, you're able to break contracts, you're able to bind minorities, and you also, everything stops. You walk into bankruptcy court, everything stops. If a company is really under distress, you get an automatic stay. You don't have to ask the court for it. It's part of the, it's part of the law in and of itself. There's no more litigation. You can stop and you can start putting your house in order. The costs, of course, it's expensive. And you need financing, because you can't walk into bankruptcy court and the judge doesn't hand you a check to run your business. You still need financing. And there's a potential loss of control of management. That's rare, but it is potential. And of course, there can be a negative impact on customers. When you hear, and I know you're all familiar with the phrase Chapter 11, someone's going Chapter 11, it raises the attention and it raises the blood pressure of everybody that's involved. So that's why we like prepackaged bankruptcies, prearranged bankruptcies. That's where you go in and out, and it's really become popular. Sheron and I and other members of our firm, we're a litigation firm. We're brought in very difficult situations where you need to have the strength of a litigator in order to achieve a certain outcome. So we like to say that litigation is one arrow in our quiver, but it's only one arrow in our quiver because the goal ultimately is to use the litigation to bring people around the table, get stakeholders to really grasp what their economic rights are in an entity, and then use that to drive a deal. And that would be a prepackaged or a prearranged bankruptcy. In Delaware, in New York, throughout the United States, you can basically get a company in and out of bankruptcy in 60 or 90 days if you've been able to reach a deal with your stakeholders. Sometimes you need to litigate with them in state court. I'm in a case right now in Las Vegas, Nevada, where we are at odds with not distressed hedge funds that invest in distressed securities. They're not distressed. The company's in distress, and we are in a state court litigation that's going to have to play out for a little bit. Once it does, there's going to be a possibility that there could be a prepackaged or prearranged bankruptcy where we utilize the benefits of the bankruptcy court, but we've already cut a deal with everybody. And that's something that we recommend to companies. I should say, as a bit of disclosure, we tend at Kasowitz to represent people on the creditor side, not as much on people on the company side, although now I'm doing a lot of company side work too. It gives us the insight into the way creditors think. We've been representing hedge funds in the distressed market for quite a bit. And on the company side, we work hand in hand, as I said, with in-house counsel because the in-house counsel knows its operations, knows its senior management, and knows who the stakeholders are, at least the principal stakeholders. So they bring us in, and we're able to work effectively with them in order to get the company through both its balance sheet restructuring and its operational restructuring. The debtor's goal, of course, is to discharge its debts and to move on in a new iteration, maybe somewhat smaller, maybe giving up certain divisions, and reorganize its capital structure. Of course, and this is where the duties of directors come into play, which is very important, and that is that there is what's called the absolute priority rule, and the equity holders of the company come last, the creditors come first, because the creditors originally, when the company was solvent, they made a deal only to get back what they had lent the company. So if the company flew through the roof, like Israeli companies typically do, and they would get none of the upside from the equity returns. But what they do get is if things turn the other way, the equity does not realize until the creditors get paid in full, and that's the absolute priority rule. Chapter 7, I told you, is a liquidation. We don't typically do that. You have that in Israel. In Israel, where you go into a liquidation proceeding, and then a trustee or a liquidator is appointed. In the United States, we have a trustee, and their senior management is then taken out of the company. The board is taken out of the company, and the actual liquidator is the one who takes the assets and disposes them. Very rarely used for companies. Most companies are in Chapter 11. In Chapter 11 in the United States, the senior management, the board of directors, everybody stays in place. The company operates under the business judgment rule. It goes into bankruptcy court, and it gets its certain extraordinary business decisions blessed by a bankruptcy court, so it's binding on all of its creditors. Everybody gets a chance to be heard in bankruptcy court. It's literally incredible. You walk into bankruptcy court and you put 10 lawyers in a room and they'll talk for hours. Well, as I guess you'll see today. But the same thing happens in bankruptcy court is everybody gets a voice. However, what typically happens is that business decisions are honored by the bankruptcy judge. If you make a sound business decision, the board acts like a board should act, senior management acts like senior management should act, the bankruptcy judge is going to go along and make a determination that the board has acted in the best interests of the company. So even though there is a judge that's kind of overseeing, the judge is really looking to the board and the in-house counsel and senior management to do its job so it can say, you've exercised business judgment and I'm going to give you approval for having done so. Sales of assets, very easy in a bankruptcy, and the beauty for a buyer, outside of bankruptcy, when you're selling assets, people rely on their reps and warranties, their indemnifications, different rights they have to make sure they're actually buying what they want and people are selling what they want. In bankruptcy court, you get something that's even better than that. You get a bankruptcy court order that's binding on the world, and you get the assets free and clear, and somebody steps up 3 years later and says, no, I had a claim on that asset. Well, too bad. You were put on notice. These assets are sold. You're out. And you don't need to rely on, well, go back to the seller and say you breached a representation and get into a litigation. You've got a court order. Importantly, and this is where Israeli companies come to the United States, is we've adopted what's Chapter 15. And Chapter 15 is basically international bankruptcy brought into the United States. And where it's important for an Israeli company is if you have creditors in the United States, if you have assets in the United States, if you have a litigation in the United States, and you have some basis for needing protection either from your creditors or to protect your assets or to sell your assets, and you're in an insolvency proceeding in the state of Israel, your representative can come to the United States and institute a proceeding in the United States in order to get the benefit of many of the United States Bankruptcy Code laws in order to protect your assets and protect you from creditors in the United States. The goal, as it says, if I could see, I don't have my, oh, I have glasses, wait. It's not helping. Cooperation between the United States and foreign courts, greater legal certainty for trade and investment, efficient administration of cross-border, where you're dealing with Israeli assets and United States assets, and what you need to do is coordinate. Sometimes the judges in both jurisdictions will actually get on the phone with each other and organize which court's going to take care of which assets, and we then enter into a protocol. That happens a lot for hedge funds that are located in the Cayman Islands or Bermuda or the Isle of Man. There's actually protocols which the different courts enter into. And like I said, it protects investment, preservation of employment, facilitation of the reorganization in multiple jurisdictions. So, what's going on right now in America is default rates are beginning to increase. Over the last several years, credit has been virtually free, as we all know. It's been very easy to stay in business. A lot of companies have levered up. The capital markets were frothy for companies to take on a lot of leverage. Last year, the default rate was approximately 4.1%. It's increasing. These are opportunities in the United States and around the world for investment by firms that invest in distressed companies or even invest in healthy companies that they think are going to reach a point either in their business cycle or, let's say, in the world commodities markets like the oil business, where they see there's going to be trouble on the horizon. And these companies will take money that they've got on the sidelines right now and invest them by buying up debt securities, in some cases equity securities, typically debt securities, and begin to invest in companies that are either in decline now or that they see something in the future. So now there's increased competition in the high yield market, and as interest rates begin to creep up, what's happened, we call the amend and extend, what's happened over the last several years where companies have been able to take their capital structure and get amendments. They have covenant-light agreements. They're able to go and get more debt, or they're able to extend their debt, is going to become more and more difficult. The flip side of that is that there is more competition with money on the sidelines. There's more competition and fewer opportunities to invest in these kind of companies, so that makes it debtor-friendly also. That helps the companies at the same time as interest rates are creeping up and there's money on the sidelines that wants to come in. The more money that comes in, because there's a lot in the United States. When I started practicing 28 years ago, and when Mr. Ambassador Friedman started practicing 35 years ago, there were a handful of hedge funds and private equity firms that really invested in companies with a view towards taking over the company in bankruptcy or getting a greater return through its debt securities. Now, there's hundreds, and there's a lot of capital to deploy in that way. So what that does for companies is, since there's so much competition, you can say that there's a mispricing, really. If a company's debt should be trading maybe at 80 cents, maybe at 70 cents, sometimes it's still trading at par because there's so much money to be putting into it. So it helps the companies actually get less covenants, less restrictive debt documents. I personally think that's going to change over the next couple of years. I think it's going to become more and more difficult for companies to get the freedom from the kind of debt covenants that they've had in the past, and the debt covenants will be getting a little bit tighter. There is still a lot of money on the capital on the sideline. But you see, when oil drops as it did and becomes, hits a trough, then all of the subsidiary businesses, the companies that service them, the drilling companies, the platform companies, they all suffer distress. Investors then look at that sector, look forward into that sector, and see where the companies are going to start foundering in the future. So now there's energy. Retail in the United States is very difficult. It's very hard. Their margins have been squeezed. It's very difficult for a lot of them, particularly apparel retailers. Shipping are strong sectors in distress. Litigation opportunities remain. I know this is not the audience. That's a whole separate discussion for where people in the United States are actually investing in litigation. As I said, we're a litigation firm, so we bring that strength to the table. Recent case developments, I would tell you, I'm not going to go through what the specific holdings are. I think the importance of what's happening, there's two things that are important with what's happening in recent restructuring case developments. This talks about enforceability of make-whole premiums, which is about as boring as it sounds. But what it really is bankruptcy courts looking at documents and imposing contract law on creditors. In the old days of bankruptcy, bankruptcy courts were looked at as these courts of equity where you could go in and you could make a creative argument and you were able to knock out certain obligations that you otherwise would have because you were able to convince a bankruptcy judge that, well, I know the contract says this, but it doesn't really mean that, and what we can do is this, and the judge would listen and their shmei and dre, and there would be some kind of results that would be more equitable. Increasingly over the last 10 years, and particularly over the last several years, the upper level courts have been looking at the contracts and have been issuing decisions that are based really about the contractual rights and the rule of law. So you have lower courts, and what this talks about is a lower court decision where creditors had agreed that if they didn't get paid, or if they were paid early, they had what's called a make-whole premium. They were able to get the present value of all of the interest they were supposed to get in the future because they were paid off early, and that wasn't what their investment thesis was. The lower courts said no, they weren't going to enforce it. The upper courts enforced it. Similarly, I talked about at the outset this idea of out-of-court restructurings. Well, there were out-of-court restructurings that were really well done by the company as well as the principal stakeholders of the company, the majority holders. And the holdout creditors couldn't necessarily rely just on their contract rights. So they grabbed hold of another federal statute and they said, wait a second, there's a federal statute here that was done in the Depression era, but people haven't looked at it and said, wait a second, can you really do this out-of-court restructuring to me, even though my contract says you can, and even though you got a majority of people? And some of the lower courts, the district courts in New York, said, yes, you can. We can use that law and we can undo an out-of-court restructuring. Was a very dangerous precedent. I was in the center of the Caesars Entertainment bankruptcy, which is one of the largest, maybe the third largest bankruptcies there was in the gaming industry. And this was a very critical decision that happened in the Southern District of New York, which is one of the preeminent courts for commercial disputes. When it went to the Second Circuit, it went up on appeal. The Second Circuit reversed, and the Second Circuit said, no, this law was not designed to break up contracts or break out-of-court restructurings. The law was very clear as to what it did, and it said if you take away certain rights, and it was crystal clear, if you take away certain rights of a contract, then you can't do it. But if you act in a restructuring mode that has the effect of taking away certain rights, but is not designed to take away those rights, or does not expressly take away those rights, then you can't utilize this law. So again, to me, it's a recognition at the appellate level that the rule of law and the rule of contracts are going to be enforced. Okay, I'm supposed to take questions. The last thing I just want to mention really fast is that there was an Israeli-American case in which the U.S. court tried to reach into Israel and reverse a transaction that occurred in Israel under U.S. law, and up until recently, American courts, which are proud courts that want to reach wherever they can in the world, said, yes, we can do that. We can reach into other countries and we can reverse transactions. The trend now is not to apply our reversal laws extraterritorially. So, questions? Questions. I don't know if anybody has questions about antitrust or restructuring, but if you have any, we're happy to answer them.
Now that we delivered all כל החדשות הרעות after the exit and all of the great strategies, we got you sued for antitrust violations and in bankruptcy. So I hope we didn't ruin the mood around here, but are there any questions on any of that?
Okay, well, thank you very much for your time. We really appreciate it.